Hello friends, in the previous video we have discussed the decision given by the Supreme Court in state of Tamil Nadu versus Governor of Tamil Nadu case, and we have discussed the decision and what are the likely aspects associated with it. For example, judicial intervention and writ of mandamus, whether it can lie against the President of India, number one. Number two, if yes, then what is the position with respect to that? For example, Supreme Court clarified that there are three different aspects to it, and only in those contexts the writ of mandamus would lie against the President of India. But more important question is that recently President has sought a reference from the Supreme Court of India in its advisory capacity under Article 143 of the Constitution. Supreme Court, by and large, enjoys three kinds of jurisdiction: original jurisdiction, appellate jurisdiction, and advisory jurisdiction. As far as the advisory jurisdiction is concerned, it is very, very important from the examination point of view for judicial aspirants as well as the civil service aspirants. And there have been questions also in the previous year examination paper. Advisory jurisdiction is consisted under Article 143 of the Constitution of India. And 143 categorizes the advisory jurisdiction into two different categories. That is 143 Clause 1, 143 Clause 2. 143 Clause 1 mandates that President can seek advisory opinion from the Supreme Court over a question of fact or a question of law. Mind it very carefully. ये बहुत ध्यान रखने वाली बात है कि क्वेश्चन ऑफ फैक्ट पे भी हो सकता है, क्वेश्चन ऑफ लॉ पे भी हो सकता है. Second important point is the Supreme Court judges are not bound to give the opinion under Article 143 Clause 1. इसका एक सीधा सा कारण ये है कि 143 Clause 1 का जो टेक्स्ट है उसमें मे वर्ड यूज किया गया. मे का मतलब ये होता है परसुएसिव नेचर, मतलब सुप्रीम कोर्ट के जजेस बाउंड नहीं है किसी भी रेफरेंस को आंसर करने के लिए. इस पे कॉन्स्टिट्यूशनल पोजीशन ये कहती है कि जहां पे सुप्रीम कोर्ट को ये लगता है कि कोई क्वेश्चन जो है वो प्योरली पॉलिटिकल इन नेचर है, नंबर वन. नंबर टू, क्वेश्चन स्पेक्युलेटिव इन नेचर है, वेग है, तो सुप्रीम कोर्ट मना कर सकता है. नंबर थ्री, सुपरफ्लुअस और अननेसेसरी है इन नेचर. इन तीन पोजीशंस पे सुप्रीम कोर्ट कैन रिफ्यूज टू आंसर such reference under Article 143 Clause 1. Up till 2015, there have been 15 references whereby the advisory opinion has been sought from the Supreme Court of India. Out of these 15 references, there have been two instances where the Supreme Court refused to answer such reference. Number one is presidential reference of number 1 of 1993, and that was with respect to famous case, that is Ismail Faruqi versus Union of India, famously known as Shri Ram Janmabhoomi case. That is the popular name. The name of the case is Ismail Faruqi versus Union of India. In that case, the Supreme Court did not answer the reference because the questions were purely of political nature. Number two example is 2G spectrum case, in which the President of India referred 8 questions to the Supreme Court, but the Supreme Court answered only 5 questions. So the crux of the Article 143 is number 1, question of fact or question of law. Number 2, Supreme Court judges are not bound to answer it. Number 3, President is also not bound to follow it. Mind it carefully, it is advisory jurisdiction, it is not the appellate jurisdiction, it is not the original jurisdiction. Because otherwise the decisions of the Supreme Court are binding under Article 141, but this is not the case under Article 143. So neither the President of India is bound, nor the judges of the Supreme Court are bound to answer every such reference under Article 143 Clause 1. In fact, in some of the cases, the position has been further made clear by the Supreme Court that though the advisory opinion is not binding over the government, but the subordinate courts are bound by the advisory opinion of the Supreme Court. In the next video, I would cover the other aspects of the Article 143, and we will try to connect the 143 clause 1 with 143 clause 2. Thank you.